Yes. Reply to GFI.
My lord, I was just emailing your lordship's officer under these peculiar circumstances, the judgments, because unprepared we thought that, my lord, this will not happen.
একটু হেসে করবেন কারণ ছবি উঠছে
তো বড় উঠেছে কিন্তু আমার না
আমি এখন কাজ
তুমি আমাকে
they both of my learned friend this side, my learned junior this side, they are in attention on all over the WhatsApp groups. They have been arguing matter. I have also been, but
For
they are
which-
much more fortunate to have their our pictures have been taken and circulated.
that we are doing matters on a day where resolution has been taken.
With special emphasis on bar library members.
Because of this side. Yes.
I have been seriously reprimanded for this. But anyway, as they say, the show must go on.
5 and 6.
Well, this is a reply to our application.
I filed the opposition.
Well, this is an impediment application in a suit for recovery of possession. Well, allow me to, my lord, tell your lordship the basic facts. But if your lordship takes the cost title once
Of GA5, GA3.
of GA5 or the suit or any application. GA5 টা কোথায় গেল? GA5 টা এটা GA5
Samsung Fold.
GA5 এত মোটা হলো কি? লর্ডশিপ কাইন্ডলি GA5 টা এত মোটা
How unusual.
Yes, any FD, whatever I have all the applications here.
Yes. My lord, kindly take the cost title. Your lordship will find Bahubali Estates is the plaintiff. Then there are 4 defendants. Shivnaran Khupchand, 2, 3, 4. Now, my lord, before I take your lordship any further, my lord, kindly have a look at some of the relevant paragraphs of the plaint. Who is the plaintiff and who is the defendant? And on what basis have the defendant number 2 to 4 have been impleaded as defendants in the suit? Your lordship will find the plaint at page 45.
Yes.
যায়নি কি বলছেন পাঠিয়ে দিয়েছি আবার দুবার দুটো পাঠিয়েছি Lord, kindly take the first paragraph. Plaintiff is a company, then my lord, kindly take para 2. Your lordship will find the name of surrogates who has been referred to as joint owners of the piece and parcel of 17 kathas of land and such. My lord, kindly make a note of the premises number 9C Lotsina Road. D1 is a partnership firm and D2 to 4 are the present partners of the defendant number 1 firm. Then registered lease of 1982 between, your lordship will see surrogates as the lessors on one part and D1 being Shivnarayan Khupchand as the lessee of the other part, a portion of the property 9C Lotsina Road measuring 2 kathas. So, well, 2 kathas out of the 17 kathas form the subject matter of the lease given in 1982 by the original owners, which are the surrogates to the defendant number 1. So, well, for a period of 99 years. The Lordship will find that.
So this 2 kata out of 17 kata.
Yes. So, this is the subject matter of this present suit.
Yes.
So, this was let out by a registered lease to the first defendant for a period of 99 years. Is your Lordship found that, my Lord?
Yes, yes, yes.
Then, my Lord, kindly take paragraph 5 at page 49. Then this partnership is there. I'll not trouble your Lordship with that, may not be relevant at this stage. Then, my Lord, what they say, subsequently the partners, my Lord, the plaintiff, the surrogates formed a partnership fund, then the partnership fund became a company. My Lord, that your Lordship will find at para 6. Subsequently, the partners decided to carry on partnership business through a company, and accordingly, the company named Bahubali Estates, being the plaintiff herein, was incorporated by and under a certificate of incorporation of 1988. Thereafter, your Lordship will find there's a reference to a suit at paragraph 10 at page 53.
Yes.
এটা কোন suit? প্যারা মিলছে না কেন? But does your Lordship have the plaintiff states? Para 10. Defendant failed to deliver possession. This is after issuance of notice. In terms of the notice dated 1988, plaintiff instituted a suit in 1998 before the City Civil Court, 5th Bench City Court, as against the defendant number 1 managing partners after forfeiture of the lease under 111G. Then, my Lord, kindly turn to the next page, para 12. So, this was a suit for recovery of possession. This suit stood dismissed. Reference of which is there in para 12.
19.
Yes. 5th July 19, the said suit was dismissed.
Yes.
Then, holding that the plaintiff had failed to establish his title clearly by cogent evidence. This is what they say. Aggrieved by the judgment and decree, preferred an appeal.
So you are appearing for whom?
Now, I am appearing for a party who seeks to be impleaded in this suit. I'll tell your Lordship why. Well, kindly take para 13 now. Aggrieved, they file an appeal. The plaintiff who suits to dismiss filed an appeal before this honorable court, which was renumbered such and such. Then, my Lord, your Lordship will see. In the said appeal by an interim order of 25th June, division bench was directed to pay arrears of rent from such and such and further directed occupational charges. Then the appeal was finally allowed, para 14, by a judgment and decree passed by the division bench, inter alia holding that the plaintiff is the owner of the scheduled property and entitled to receive rent and arrears of municipal taxes, and the defendant under the lease as a judgment. So, when appeal was not allowed, appeal was dismissed. This is a mark contention. I'll show your Lordship the
Was allowed
judgment,
by a
which is
judgment
at
and decree
paragraph
passed
G. G. Well, kindly take the judgment of 13th April 2022, which is G.
Page.
This is the problem. G, your Lordship will find is at page 100 and no. 275.
$275.
This would be possibly volume 2.
Yes.
Below, this appeal arises out of the decree passed by the fifth bench by which the suit was dismissed.
Yes.
The recovery of possession suit. Now, my lord, kindly turn to page 276, the second paragraph at 276. The other issues with regard to the defective notice and forfeiture of lease, is your lordship there at 276. The other issues with regard to defective notice and forfeiture of lease are not decided in this appeal, as the said issues are not raised by such and such, representing the appellant as admitted that there has been a defect to the notice. The said property originally, then, my lord, what is decided is whether the plaintiff appellant had the right to claim ownership in the property. Only that part was decided. If your lordship will kindly come to the operative portion of the judgment, which starts at paragraph page 295.
Yes.
Second last paragraph from the bottom, page 295. On the aforesaid basis, it can be safely concluded that by reason of vesting of the property in the company by operation of law, the company has become the owner of the suit property and landlord of the defendant. In view of the fact that the defendant has categorically stated that they are willing to pay the rent to the rightful owner, and it appears that the municipal rates and taxes payable by the defendant in respect of the operation of the premises under their occupation have not been paid, we direct the defendant to pay the arrears of rent till March 2022, if not paid by such and such, and the municipal rates and taxes in terms of the lease agreement within 15th May. The decree of the trial court is partly set aside and is allowed in part. So, my lord, this suit for recovery of possession reaches a finality by this order of the appeal court. Suit was dismissed. They did not pursue the issue of recovery of possession. All that happened in the appeal was, or they pursued the issue that was pursued by them in the appeal was whether the plaintiff had the right as a landlord or in respect of the subject property. That was the only issue which was decided in appeal. So, my lord, the issue of recovery of possession reached a finality, my lord, by this judgment in 2022. Well, now if your lordship comes back to the plaint. My lord, para 15. This appears to be their cause of action. They say that there has been default by the first defendant. Well, this would be, your lordship will find that para 15 and then 16.
But 276 is stated that the other issues with regard to the defective notice and the forfeiture of lease are not decided in the appeal, as the issues are not raised.
Raised.
It has not been decided on merit.
Not raised.
Correct. So not.
So they accept the finding of the trial judge. The trial court findings the plaintiff has accepted. It was their appeal. They did not want to pursue.
What was the suit in the trial court?
Recovery of possession. Suit for recovery of possession. By that's why I showed your lordship the first paragraph.
What was the issue over there? What was the issue?
Termination of lease under 111G. Notice issued. Lease terminated. Suit filed for recovery of possession under the Transfer Property Act.
Correct.
Suit dismissed. Now, when a suit is dismissed in entirety. So they don't get their decree for recovery of possession for which they instituted the suit.
Correct.
Suit failed.
Correct.
One of the issues that were decided in the suit was their title. Whether, my lord, whether by virtue of the partnership firm having been converted into a
Please and all.
company, and whether the surrogates initially who had granted the lease formed the partnership firm and subsequently the company, well, whether they otherwise retained title and could be considered to be the landlord of the defendant. That was the only issue that they pursued in their appeal. So they consciously abandoned the other issues. So they did not. So the recovery of possession by forfeiture of the lease initiated by them against the defendant came to an end in 2022 with the disposal of the appeal. Now, the second round starts. Now, your lordship will find now para 15 of the plaint. They say that in terms of the order of the appeal court,
They paid up to the June 2021.
yes, that's the allegation. I'm not going into the merits of the allegation. They say so much is due. And they also say that there has been breach in violation of the terms and conditions. This is in respect of the 99 years registered lease. Now, in view of the deliberate breaches, there seems to be a letter which has been issued. There's a reference to a notice of 9th August 2023 terminating the lease of 1982. Then, my lord, kindly see. My lord, kindly once take paragraph 20. My lord, kindly take para 20 and 21.
Why not 19? Despite receipt of the notice,
Yes. Notice, then there's a reply given by the defendant number 1 to the notice, then the suit.
Yes.
Now, my lord, what is part of the plaint is the lease. So your lordship can look at the lease. Now, my lord, kindly have a look at the lease. The 1982 lease. My lord, which starts at, there's a typed copy as well. My lord, kindly turn to page 74.
So who are you?
Now.
That is the point we were just discussing. But third party in a suit for eviction.
Third party. Now, this is the
Yes.
interesting part.
Why third
Now,
party?
who am a third party?
Only
Now,
when-
allow me to answer that.
Just one
My addition of party
Well, if I
application.
may just put my learned friend's case in one line, whether in an eviction suit on the ground of forfeiture of a registered lease, a sublessee put in possession by the lessee is a necessary or a proper party. When the lessee is already the defendant number 1, whether the sublessee can have any right to be added, and he is claiming his right in terms of the lease through the lessee. This is the one question.
This is one of the classic cases. 82, 99 years lease given with a right to construct and sublet.
To whom?
To the first defendant.
Correct.
Right to construct and sublet.
Okay.
So the defendant number 2, and there is no right of re-entry, no right of forfeiture. So the agreement must run its entire tenure. That is the law. There is no right of re-entry, no right of forfeiture. Why? Because the lease specifically contemplates that the first defendant will demolish the existing structure, build the new building, and then sublet. So he is authorized not only to construct but to sublet. Now, what the first defendant does, based on the lease, he constructs a building and he assigns the unexpired period of the leasehold interest, that is the 99 minus whatever is left, which was taken by him to construct the building, to several third parties, out of which I am one. So I have a unit in the subject property which was assigned to me by a registered instrument, the unexpired period of the lease. So I am in possession. Now the defendant number one, like the proposed added defendant, has let out several other portions of the building to several other third parties. So the defendant number one technically is not in possession of any part or portion of the suit property. So he has constructed, made his money, walked out. So his only obligation is to pay this princely sum under the 82 lease to the landlord. So effectively, it has the trappings of the sale. Now the question is that this previous suit thereafter, Malad, this is a complete collusion. I have filed two separate suits. There is a suit pending before this court where I have independently filed a suit. Now, Malad, this action, the subsequent action.
What is your suit for?
My suit is for declaration of tenancy right. I have filed a suit before this court that I say that this, by virtue of this lease, the plaintiff, I have both the defendants, or both the lessor and the lessee, which is the plaintiff and the first defendant in this suit, as a defendant in my suit. I say that in my suit that he has no right of forfeiture and there is no right of re-entry. So the suit that you have filed or the proceeding that you have initiated is nothing but a collusive proceeding in which I have not been paid a party, and I have in my suit said that I am applying to be implicated as a party in the suit. Why? Because this action is nothing but a malafide action on the part of the plaintiff and the defendant number one to get a decree for eviction, because the defendant has nothing to lose. He is not in parted possession of any part of the property. So even if there is a decree for eviction, he'll be happy to give, not to contest the suit, or so to say, defend his action so far as recovery of possession is concerned.
Who are in possession?
We are in possession. We are the authorized sublessees with the unexpired period of the lease, which will be evident from the lease itself.
By whom?
By the defendant number one. Now, who gave the right to the defendant number one? The plaintiff. What right did the plaintiff give? To construct, sublet, and not to forfeit the lease during the tenure.
Correct.
So the previous forfeiture was bad, and the present forfeiture is equally bad. So if you don't have a right under your indenture to forfeit the lease, where is the question of, my lord, seeking recovery of possession? Now, my lord, that is why we say that we are a proper party. Now, the concept of proper, I don't say I'm a necessary party. Decree can be passed in my absence. But proper and effective adjudication of the issues in the suit, my presence is necessary. Because this is apparently a collusive proceeding. The defendant will create a pretension that I am defending the suit, but effectively will not defend the suit. Because he has nothing to lose. Because if your lordship looks at it, he has constructed, he's a builder, he's constructed, let out.
Who are the defendant in your suit?
My lord, in my suit is the original, the plaintiff here, and the first defendant. Here, if your lordship looks at the cause title, in my suit, I have implemented both the plaintiff and the second defendant, a first defendant. So technically, effectively, my lord, both the suits should ideally be heard together. If I succeed in my suit, logically they should fail in their suit.
That's why.
Now, the problem is, if I am not a party in this suit, nobody is there to defend the suit. So decree will be in a matter of course. Defendant will, this is our apprehension, of course, that the defendant will pretend as if we are defending the suit.
Who is appearing for the defendant? You are supporting plaintiff.
I have an independence. Neither supporting Mr. Bose nor Mr. Mr. Bose's submission is very interesting. We will show his pleading. He has got the entire records of my suit from defendant number two. That is his case. And he pleads
so that affects
collusion
my
between
right.
me and them.
That affects my right.
No one is saying. I'm saying on the collusion part.
No, I will show how many suits are pending. Now, interestingly, your lordship will find in respect of the same subject, probably that total 4 suits pending. I had previously filed 2 suits. They had attempted to mortgage the property.
What has happened to the two?
So, my lord, now what had happened is, because of this, they withdrew the suit. That means in 2022, when the appeal was disposed of, that means they accepted that they are not going to proceed to evict.
Naturally.
So naturally, so that point of time, what happened? If there was a compromise, the building was in dilapidated condition, it repeats very well. We are not pursuing our right to evict the defendant number 1 because they have accepted the position.
So when you came to the possession, that the suit
I-
pending before the civil suit, the
I have
civil
been in
court-
possession. I have been in possession technically from I think 1990
So the suit
under a
filed before
registered
the,
instrument.
the suit filed with the before the civil court, you have not been implicated as a
No, no,
the appeal also you not entered.
no, because you see, your lordship, I had filed independent suits there.
Correct.
Now the situation is different. Then the situation was different. I was under the impression that the defendant will genuinely defend his interest in the property. But now the collusion is apparent. This is our apprehension, and today that apprehension is become, well, we have sufficient reasons to believe that this is no more an apprehension. This suit, after the dismissal of the appeal or after the disposal of the appeal, the subsequent suit, by alleging that he is unable to pay the rent based on that same 1982 lease agreement, is apparently a collusion.
No, because 1988 agreement, correct?
1982 agreement.
Correct. That why it should be renewed? Because it is continuing. The division bench of appellate court has passed an order. Okay, you pay.
Correct. You pay and the lease continues.
Continue.
So the
And
99
now
years lease.
Now they have made out together from 23. They refused to pay. They failed to pay the amount. That's why they have initiated the
No, my lord,
process.
interestingly, your lordship will find there is a that will take me into the merits of the suit.
Correct.
I will proceed on the assumption that the averments made is true and correct.
Correct.
So the case that they have made out is, after the disposal of the appeal, there is a default on the part of the defendant in making payment of the areas of rent and the municipal rates and taxes. That's one. Number 2, they also allege that there has been breach by the defendant number 1. So they have once again forfeited. They have given a notice of forfeiture and subsequently the suit. This is their case. Now, my lord, my respectful submission before your lordship, on the basis of which I filed this application, is that, my lord, this is nothing but, my lord, this is in collusion with the defendant number 1. They are in concert with each other. Otherwise, they need a ground. Now, if they have to evict all the occupants of the building.
Suppose if the defendant number 1 is not in possession of the property.
Correct.
You are in possession of the property
Yes.
and not the party.
Yes.
So what is the defense taken by the defendant?
But that too I wouldn't know.
How you can say
In
this
my suit. No, I am saying apparent collusion. Why? Because today, if your lordship will see, they suffer an injunction, there is no appeal. At the ad interim stage in this suit, an injunction is passed. The defendant doesn't oppose. Now, apparently at the initial stage, they had taken all the defenses. Now they say that, my lord, we have come to know that there is no arrears of rent. Everything has been paid. In fact, my lord, from the orders of the court, it appears that at that stage, what was paid was in excess. That's why the appeal court says arrears of rent, if any. So there was nothing arrears in rent. What they had paid was already in excess. That had to be adjusted based on the order passed by the appeal court. So there was nothing. So all that they could bring an action was based on forfeiture. Nothing more than that. So now the forfeiture is not permissible under the lease agreement. Now, how is the defendant not defending a suit? And we have also sufficient reasons to apprehend that the defendant will not defend his interest because there is no interest in the property, so he has no
What is the-
occasion to defend it.
What is the schedule of property in your suit?
My lord,
Same.
my suit scheduled property is 1 unit, which is a commercial space, which I use for my registered office. First floor and second floor.
To whom you are paying the rent?
To the defendant number 1. Because I have the unexpired period of leasehold interest. So, my lord, what has been given to him has been effectively transferred to me. So, what right the defendant had under the 82 agreement has been assigned to me. So, automatically I step in because you have given under the 82 agreement the right to the defendant, the first defendant to sublet. If your lordship sees the some of the clauses of the 82 agreement, it will become
So in
absolutely
your suit,
clear.
In your suit, you made the defendant number 1 also.
Yes,
defendant?
absolutely.
What is the prayer against the defendant number 1 in your suit?
My lord, the prayers.
Declaration.
My lord, declaration.
Declaration against the plaintiff. What
No,
about the
against me,
Ah.
exactly. That I
Against
can't
him,
terminate.
and he is a proper party because he is the one who has given me the unexpired period, the leasehold interest. So he is also a necessary party. Without him, I cannot get a decree in my suit.
correct?
So, my lord, so that is my suit. Amar suit.
Okay.
I'll just give your lordship the. I'll just give you. I'll give your lordship the prayers in my suit. বলেছি কি? দেখো। What I have stated in my application, if your lordship sees, I'll just read out for your lordship consideration. I'll hand over thereafter lordship a copy of the print. Well, these are the reliefs that I claim in my suit. I claim a declaration declaring that the lease deed dated 17 June 1982 between surrogates and the defendant number 1 is not determinable. Decree for declaration that as a consequence, the right, title, and interest of the transferees of the defendant number 1 is also not determinable. Consequential, if 82 D1 is not terminable, you cannot, by virtue of that, you cannot terminate the subsequent as well.
B prayer?
My lord,
Not B prayer B?
decree for declaration that as a consequence, the right, title, and interest of the transferees of the defendant number 1, which is me, is also not determinable. Decree for declaration that the defendant number 1 and 2, which is, my lord, the plaintiff and the defendant number 1 here, has no right, title, and interest to create any right in favor of any third party in respect of any part or portion of the suit property, inconsistent with the plaintiff's right under the registered instrument of
Defendant number
2004.
1 has determined your agreement.
No. Then I will be in a difficult position. And naturally, because I am the person who will be affected by the decree. Any decree passed in the suit.
So defendant number 1 has not determined your
No.
and you are continuing in possession.
Absolutely.
And you are paying the rent.
Absolutely. To my lessor, which is the defendant number 1. Now, the defendant number 1's right, which he has transferred to me, is based on the 82 lease. Now, my lord, if your lordship kindly take.
If at all,
Yes.
if at all, okay, defendant number 1 is not contesting or not
Right.
proceeding properly.
Right.
What defense you will take in the suit, in this present suit?
That he is not entitled to a decree based on the 1982 lease, because the 1982 lease cannot be forfeited. There's no right to determine the lease. So, if I hypothetically, if I get impleaded,
Then counterclaim.
then what I will do is that I will defend the suit to contend that the 82 lease, on the basis of which you have filed the present suit, you have no right of forfeiture, you have no right of re-entry. So your suit is not maintainable. You cannot bring an action against the defendant number 1 for recovery of possession during the tenure of the lease.
99 years.
99 years.
So-
That was the whole object of the lease. Because you gave a right to construct and sublet. And specifically, it's mentioned in the lease, not one. There are multiple clauses in the lease from which, it would be evident that the parties consciously did not want or consciously entered into a contract to ensure that the lease runs its entire tenure and it cannot be determined during the period of the lease. This is effectively the 1982 lease. So, my case is that the 82 lease and the judgments, that's all. So, can I come back on the next day with this? Well, I have effectively utilized your lordship's time. Actually, the difficulty is that we were unaware that it would be taken up. These are my contentions. I will show your lordship the 82 lease, the covenants of the 82 lease, and particularly two judgments.
That would be
which,
going into the merits of the matter.
No, the lease
I
is a
don't
part of
think
your
in an
plaint.
addition of party you can go into the merits of my plaint.
No.
You have to show that you are a necessary and a proper party.
How do I show it's a necessary party?
Not
Because
going
my
into
rights
my
are getting affected.
Not going into my lease.
The moment, in order
there are
to justify that my rights stands affected.
So why you're not taking out an application for analogous hearing of both the suits
For
instead of both the suits?
The difficulty is that once I get impleted, I can. Without being impleted, how will I do that? No, but then the principles of Section 10 will not apply.
No, Section 10 will not apply.
No,
you are not a party here.
You
How
are not a
Section
party
10 applies?
here.
no.
But
Section
your right
10
is created as per your case.
No,
your
they will
right-
say if I file an application which
But my
approaches
learned
from your
friend has,
lordship,
I just cut the matter short. My learned friend has to show your lordship that similar application has been filed by him for addition of party in my city civil court suit. When my city civil court eviction suit was there, he applied for addition of party. It was rejected. Even the revisional court of this honorable court also dismissed his revision. That is staring at his face. He will have to explain how, my lord, that will not bind him here. And that has framed the question of law that whether a sublessee claiming through a lessee who is impleaded as a suit can again ask for addition of party when the lessee is already there.
that
And the sublease is with the consent. It's an authorized sublease. It's not
Then-
that the sublease has been granted
unauthorized.
with unauthorizedly. Then it's a different thing.
No.
So these are the questions which have already been framed in the coordinate bench judgment. So that will
the
now
only
my learned
difference is
friend will
that
have to-
coordinate bench judgment at the time of city civil court suit, that fraud issue was not there.
that does not matter.
No, that is the only
Well,
that is the
Supreme
only
Court has
matter
taken
now.
into consideration mere allegation of collusion, because you will have your remedy elsewhere.
Correct.
How will I have my remedy?
Yes, you will have your remedy elsewhere.
Say if you get a decree, you will execute the decree.
You will have your suit. You have your independent suit today.
No, the difficulty will be conflict.
That's why we can't have a separate voice.
You will have to raise your point of fraud and collusion at the execution stage by 47.
No, but
That
the
is the-
only difficulty is that, my lord, this is a very peculiar situation. In a situation like this, my lord, there's a recent judgment of the Supreme Court. Supreme Court has, my lord, trial court allowed impleadment of a defendant. High Court set aside in civil division because it was before the trial court. It was not an intra court. Supreme Court examined and following, my lord, Kasturi and Mumbai International held that no, he is a proper party because his rights would be affected if the suit is decreed. So he has to be impleaded. So based on those principles, I am saying, my lord, this should apparently be in a collusive suit. Even otherwise, I am otherwise a proper party in view of the, my lord, 1982 lease and the subsequent, my lord.
But only one thing, my lord, in GA number 3, my lord, the interim order has to be extended, my lord.
My lord, the unopposed interim order. No, written,
Yes,
of
yes,
course,
no,
written
no,
statement, of course.
Acha, not that way.
This is last minute entertainment for all of us.
Learned counsel for the intervener has argued the matter at length, but due to positive argued the matter at length. Your petition GA5, na?
5.
In connection with GA5 2025, but due to paucity of time, hearing could not be completed. according cases adjourned. Counsel for the plaintiff prays for extension of the interim order. In view of the circumstance, in view of the above, the interim order is extended. क्या डेट कब है? और कुछ नहीं. 12:30. 3rd November. 3rd November at 12:30.
Yes,
Interim order is extended till 3rd November at 12:30 or
Great.
until further order, whichever is allowed.
kindly give me one day after
Because
because
12 November बोला ना,
some uncertainty always
3rd
looms.
November बोला ना, and 7th November interim order till 7th November or until further order. Let the matter appear on 3rd November 12:30. Interim order is extended till 7th November 2020 or until further order, whichever is allowed.
দিয়ে দি দিয়ে দি। এটা কি?